Do you have? Perfect. We are recording. You will be emailed a copy of the recording as well. We're going to post it to YouTube later on. But welcome. Thank you for coming to our workshop this week. And with that, we will pass it off to Patricia Minikin, who, as I mentioned, she's an attorney who specializes in immigration law. She has decades of experience in immigration law and has been helping the university and university graduate students specifically for a number of years as well. And Simone, do you have her PowerPoint? Perfect. We have slight technical issues, so Patricia's on the phone, but we have all of her information with PowerPoint, so thank you for your patience. But with that, Patricia, your title slide is up and you can begin.
Okay, thank you, Zach. Well, good afternoon. It's always a pleasure to share information with the student body, and I will begin. Today's presentation discusses pathways to get a green card. At the end, I will address, during the presentation, I'll be addressing some questions that came in and that fit nicely into the presentation discussion. And the other questions that do not, I will be answering during our question and answer period immediately following the presentation. If you have any questions as I present, please type it into the chat room, and our moderator will be reading those questions out to me during the question and answer period. And I believe you'll also be able to ask questions, when I'm done. Okay, now I will be moving on to the presentation, pathways to get a green card. There are several paths to get a green card in the United States. Some are through humanitarian programs that grant you a non-immigrant visa for X number of years, and then you qualify to file for a green card after, that number of years. Others are through specialty programs designed to benefit certain nationalities or certain occupations abroad. And the third and fourth are the most commonly known paths to a green card, which are family sponsorship and employer sponsorship. And then there is self-sponsorship, which can get you to a green card. For example, national interest waiver, investments, or someone from the EB-1A category. Next slide. So one humanitarian program that provides a pathway to a green card is asylum. This is where a person fears return to their home country based on persecution because of their religion, particular social group, race, political opinion, or nationality. The persecution needs to rise to the level of serious harm that threatens life, liberty, or the ability to survive in that country, meaning if your ability to attend school or to get a job is seriously affected due to the persecution, it can rise to the level of a claim that would afford you protection by U.S. immigration law. Caveats for asylum is that you need to apply within 1 year of entry, or you need to apply within 1 year of the changed circumstance that causes you to apply for protection or asylum. After being granted asylum, you qualify to adjust your status to that of a permanent resident after 1 year, but you cannot return to your home country where you claim persecution until you're actually a U.S. citizen. And because you're able to apply after 1 year of getting your asylum, you would be then able to apply in 4 years to become a U.S. citizen because you are credited for that 1 year you spend in asylee status after being granted asylum. Next slide. Another humanitarian program is the T visa, T for trafficking. It is a temporary non-immigrant visa given for up to 4 years to someone who has been a victim of sex or labor trafficking. Sex trafficking is where you're coerced or induced by force, fraud, or fraud to engage in sex acts for pay, commercial sex acts, or you are a victim of labor trafficking. That means an employer has obtained your labor services through the use of force, fraud, or coercion, which renders you in a position of having to give involuntary servitude, to be the person's slave, or peonage or debt bondage. You need to assist law enforcement in the investigation or prosecution of the trafficking if you're an adult. And you can then, once you're granted, you can adjust your status to that of a lawful permanent resident after you have been in T non-immigrant status for 3 years. Next slide. Another humanitarian program is the U visa. This is for persons of specified criminal activity like rape, murder, domestic violence, felonious assault, like where you're mugged at gunpoint or, with some other weapon, blackmail, stalking, witness tampering, and any crimes related to one of the enumerated crimes would qualify. The victim must suffer mental or physical harm. So, for example, some people develop PTSD from being held at gunpoint. You have to be helpful in the investigation or the prosecution of the crime, and you must obtain certification by the law enforcement agency confirming that you were indeed helpful. The crime must have occurred in the United States, and again, persons approved are given a temporary U non-immigrant visa for 4 years, and after 3 years, they qualify to adjust their status to that of a lawful permanent resident. Next slide. The final humanitarian program we will discuss is the Violence Against Women's Act, which applies to males who are abused and suffer battery or extreme cruelty by a U.S. citizen spouse, a former spouse, parent, or child, or a lawful permanent resident spouse, former spouse, or parent. If granted VAWA benefits, that person can apply to adjust status to lawful permanent resident. And if the person is in removal proceedings, they can defend against their removal from the United States if they have lived in the U.S. for 3 years. The normal requirement to obtain that relief, which is called cancellation of removal, is residence in the U.S. of 10 years. Next slide. So there are occasions when Congress will pass laws that grant citizens of certain countries a green card, or certain persons who were engaged in certain occupations abroad will qualify for a green card. So right now, green cards are available for Afghans and Iraqis who were employed by the U.S. government abroad during Operation Enduring Freedom, which until the troops were withdrawn under the Biden administration was an ongoing war. Anyone who is a special immigrant juvenile and has been granted that status because they came to the U.S. without their parents, but were abused, neglected, or abandoned in their home country by their parents, and a state court judge has made a finding that it would not be in their best interest to return to their parents' country of nationality, can also apply for a green card. Any broadcaster for a U.S. agency abroad or grantee of the U.S. Agency for Global Media can also apply for a green card. A retired employee and their family members of eligible international organization or NATO 6 can also apply, as can former U.S. government employees abroad. Usually the U.S. Embassy employs local staff, and those persons, after they've served for multiple years, usually when they retire, can apply for a green card. Next slide. Just a second. Okay, there we go. The family, under family sponsorship for a green card, if you are an immediate relative, you will not have a wait, but you'd have to be the spouse, parent, or child of a U.S. citizen. There is no penalty if you're not in status at the time you apply for adjustment of status. You're still able to do that if you're an immediate relative. Also, if you're an immediate relative and you enter the United States, you are able to apply to adjust your status right away within 90 days. Usually, if a person enters the U.S. and then applies to adjust their status before 90 days have passed, they are presumed to have entered the U.S. with the intention of residing permanently, of being an immigrant, where they have entered with a non-immigrant visa, like a student visa or visitor's visa, but that does not apply to immediate relatives. Now, there are categories that involve a wait, sometimes a very long wait, for an immigrant visa, which is the same as a green card. If you fall into one of these categories, they're called preference categories. That is because there's only a limited number of visas available in each category. So if you fall into one of these categories, you may have to wait in order to get a visa, and you must be in status at the time you apply to adjust your status if you fall into one of these categories. So you would have to maintain status during that time. One such category is an adult child over 21 of a U.S. citizen, spouses, unmarried children under 21 of permanent residents, and unmarried adult children over 21 of permanent residents. All those categories must maintain status. And I know some students who may fall into this category may wonder, how does applying for permanent resident status affect their student status? The issue here really is you affect your F1 non-immigrant status if you apply to adjust your status to permanent residence status, because F1 status is non-immigrant. You're guaranteeing that at the end of your studies, you'll return home. And whereas when you apply to adjust your status to being an immigrant, you're saying, I'm applying to remain in the U.S. Forever, and I do not want to return home. So they do contradict, you know, anyone who is in that situation, it's best to get one-on-one counsel from an immigration attorney, because each situation is different. There are ways to sometimes time the application so that, say, for example, you apply to extend your OPT. If it's a STEM, if you have a STEM major, you apply to extend your OPT before you apply to adjust your status. Next slide. The process for family-based immigration is there are forms, either the family member petitions, files a form called Petition for Relatives, and then you support the relationship. So if it's a spouse, You would submit the marriage certificate, proof that the spouse is a permanent resident or U.S. citizen. If it's a child and parent relationship, you would submit the birth certificate to show the relationship between the parties. If it's brother and sister, you would submit each person's birth certificates to show parents in common. And then you need to submit to a criminal background check. USCIS will schedule that, and later on you'll be scheduled for an interview. And when you're scheduled for the interview and when you can adjust status is based on visa availability. So for immediate relatives, they have a fairly seamless process where they move from form filing to interview and then, granting of the green card. If it's a marriage-based petition, though, and the couple have been married for less than 2 years, the person receiving the green card will receive a green card that's valid for only 2 years. 90 days before the second anniversary of the card, that person will need to file along with their spouse and demonstrate that they are still in a bona fide marriage, they're still commingling assets and liabilities with their spouses. If the parties get a divorce before the 2 years are up, it will affect the conditional or lawful permanent residence in that the conditional permanent resident cannot file a joint petition to remove the conditions on their residence, and they will then need to apply for a waiver of their spouse's signature because they're no longer together. Usually you can file for this waiver if the marriage has ended, but you can prove you entered in good faith and it ended through no fault of yours, or if the conditional resident was subject to abuse. Divorce does not affect the affidavit of support that the petitioning spouse had to submit to immigration. That affidavit of support is a contract saying that the petitioner will support the family member that they're sponsoring to get a green card in the event that the family member can no longer be self-supporting. Some people during a divorce get a court to order support on that basis from the spouse who was the petitioner. So the affidavit of support survives divorce, you still have the obligation, and it can actually be used during a divorce for the court to award spousal support even where the spouse would not get alimony. If a person applies for a family-based immigrant visa, the application is scrutinized for fraud, either fraud in the marriage where someone is being paid to petition for another, or the person is petitioning for someone they have no relationship with, but maybe are very good friends and they don't want the person to leave. If that is the case, if someone receives a finding that they have engaged in marriage fraud, they are barred from obtaining a green card through any other means. Next slide.
Patricia, before we move
Turning
on to
to
the next slide, there's a question in the chat. Just a clarification, are these conditions for applying for permanent residence or applying for a visa?
permanent residence status is permanent residence status is the end result of an application to adjust your status or an application for an immigrant visa. So an immigrant visa is the same thing as permanent residence status, and it's the same thing as having a green card. All right, turning to employer immigrant visas through an employer. You get an immigrant visa through an employer who sponsors you. There are different classes of employment-based visas. So there's the EB1, EB2, EB3, EB4. We will discuss shortly the differences between these various categories of employment-based visa. But for now, I'm just giving you an overview. There's extraordinary ability, advanced degree, or exceptional ability. And then there are those, the EB3 category is for persons who possess a bachelor's degree or persons who possess no degree. And then there's EB4, which is for special immigrants, religious-based, and EB5 is for investors. Next slide. The first preference is comprised of priority workers. These are persons with extraordinary ability in the arts, the sciences, education, business, or athletics. They can also be outstanding professors and researchers, or they could be certain multinational managers and executives. Next slide. The second preference is comprised of members of the professions who hold an advanced degree, meaning master's and above, master's, PhDs, or it could be an exceptional ability person. And under the second preference, persons who qualify also have the ability to self-sponsor without a job offer. The EB3 category consists of skilled workers, professionals who only have bachelor's degrees. Skilled workers usually do not have a bachelor's, or they have an associate's. Other workers would be someone under the EB3 category who only has maybe a high school education. The EB3 category requires labor certification through the PERM process. So there's more required for the category that has, that requires less education. Next slide. Now, the labor certification through the PERM process is required for EB2 advanced degrees or exceptional ability who have a job offer, and as I stated, for the EB3 category as well. To engage in the labor certification through the PERM process, the employer files a labor certification application and then must advertise, meaningfully recruit, and then provide a result of recruitment report when they file the labor certification application. If the Department of Labor is not satisfied with the recruitment process, they could require the employer to engage in recruitment again, but this time the Department of Labor will supervise the recruitment, whereas the normal PERM process, the employer recruits as long as it's within the 6 months or no later than 6 months before he or she files the labor certification application, that recruitment would be fine. Next slide.
Patricia, we have another.
No labor.
Someone asked, roughly speaking,
Okay.
how long does it take for the green card process for EB2, and is there an expedited option?
Okay. I do address that later in the presentation.
Okay.
There is no expedited process,
Okay.
but I will talk about processing times.
Okay, perfect. Thank
So
you.
turning to employment EB visas where no labor certification is required, even though the person has a job offer and an employer. The first categories are persons on Schedule A. Schedule A is basically a list the U.S. Department of Labor maintains of professions in the United States that are in short supply. So right now, physical therapists and professional nurses that is someone who has a Bachelor of Science in Nursing, qualify, and do not need to go through labor certification or PERM. The second is group 2, immigrants who have exceptional abilities in the sciences or arts, including college and university teachers, and immigrants of exceptional ability in the performing arts. Then you also have the extraordinary ability, EB1, and the EB1 outstanding professors and researchers, certain multinational managers or executives. All of those persons do not require labor certification. Next slide. Labor certification has some benefits, especially for persons who are from India and China, because they have such long waits for employment-based visas. If your labor certification has been pending for 365 days, you can renew your H-1B visa beyond year 6. That also applies if the employer petition has been pending for more than a year. You can also do that. So that way you maintain status until you can apply to adjust your status to that of a permanent resident. The H-4 spouses can obtain work authorization if the application has been pending, if the spouse who is the principal H-1B's application has been pending 365 days, or after the employer petition has been approved. Next slide. After the PERM process and after the labor certification is approved, the employer then has to file an employer petition similar to a relative petition, but this time it's by an employer for a prospective employee or current employee. So the employer files that petition, and the focus at that point is on the employer's ability to pay the worker. And approval means that the employee can apply for lawful permanent resident status when a visa becomes available. Next slide. Now, there are categories where a person can sponsor themselves, and what this means is no employer is needed, and sometimes no job is needed. So the person, if it's extraordinary ability person or individual, that person would need to provide evidence that they've won prizes, awards, that they are a member of association that require outstanding achievements, they've published in professional and trade journals and publications. I know people talk about citations, and those are nice to have, but it is a stronger application that shows that your work is being cited to support, in a way that adds to the body of knowledge in your field of expertise, as opposed to, say, for example, you're being cited in like a string citation that doesn't really show how the work that you did in your research is contributing to the field. You also may want to show you've judged the work of others, that you've made significant contributions to the field, like I said, by the citation. Next slide. One way to self-sponsor is to apply for a national interest waiver. You're basically asking the U.S. government to waive labor certification and the job offer because your immigration to the U.S. would be beneficial to the United States in such a way that it would be nationally important to the United States and benefit the United States much more than having you go through the labor certification PERM process would. So you need an advanced degree, or you need to show you have exceptional ability. You have to demonstrate that your proposed endeavor has both substantial merit and national importance. So basically, you're proposing that you be allowed to become a permanent resident so you can engage in some sort of work that would benefit the U.S. So you always need a proposal. You always need to make your case as to why this project that you will work on or the research you will be doing, why it is of national importance, why it has substantial merit. You know, why is it important to the U.S.'s well-being, economy, etc., safety, security. You have to show that you're well-positioned to engage in this project. STEM PhDs are presumed to be well-positioned and that the project that would advance would have substantial merit. They still need to show benefit to the United States, though. Next slide. With the national interest waiver, like I said before, no employer petitions required, no labor certification of perm is required. If you have a government agency that you collaborate with, who you may get letters from them so they can say in their letter how helpful your project is, your research is to, you know, their whatever project they're working on that intersects with your area of expertise. You usually want letters of support, if not from an interested government agency, from leaders in your field, because you want to say, you want someone other than yourself to be saying why your project has substantial merit and is important to the United States. The project can also be entrepreneurial in nature, meaning you could apply based on, say, having a technology or having a patent that you want to produce for mass market. You know, so it can be a business project as well. Next slide. You can also self-sponsor by investing $1 million in the U.S. economy. That $1 million has to be at risk. If you're investing in designated areas of low employment, you can invest $500,000. Again, it has to be at risk, meaning you can't just have the $1 million in the bank, but you need to actually invest it and have the risk of losing that money if the business goes belly up or, you know, the business fails. You need to create jobs for at least 10 U.S. workers, and you're only given a green card for 2 years because at the end of the 2 years, you need to show that the business is still operating, it's still employing at least 10 workers, and it is still in the, if it's a $500,000 investment, you need to show that it is still located in that area of low employment. Next slide. The processing time as of October 2022 for a family-based green card is 34.5 months. So pretty close to 3 years. And employment-based green cards are taking slightly less at 31.5 months. And this is as of this month. And that's to address the person's question about the timeline. So it's included on the slide. Next slide. But this is where I answer some of the questions that didn't quite fit into the discussion, and then we'll move into questions from the audience. So how does applying for a visa affect F1 status? I addressed it a little bit. And with that, I will say, you know, you're contradicting yourself if you have an F1 visa, which is non-immigrant and which requires you to return to your home country, and you apply for an immigrant visa, because you're now saying, I want to stay forever. But some people mistake applying for an immigrant visa for their parents applying for them. You know, like I said, applying for an immigrant visa requires the student to make an application and sign that application, either to apply for an immigrant visa abroad or to adjust their status if they're already in the United States. And when should a PhD apply for permanent resident status? Well, the answer to that is it depends. And if, you know, any of the students who submitted these questions in advance are on or are in the Zoom room, please feel free to clarify what you mean. So it depends on what path to permanent resident status the PhD is applying for. For example, if the PhD is applying for a national interest waiver and STEM PhDs are assumed to already meet 2 out of the 3 requirements for the national interest waivers, then that PhD might want to wait until they have their STEM degree and then apply. Maybe if they have a job, well, even if they don't, they would apply for 3 years of their STEM OPT, and in those 3 years of OPT, they can apply for the national interest waiver. Does a particular citizenship affect chances of obtaining a green card? Well, let's put it this way. Certain citizenships from countries that are designated as enemies or axis of terrorism to the U.S. would undergo more scrutiny than someone from a friendly nation. So say, for example, an applicant for Iran might have more scrutiny than an applicant from the United Kingdom, because the UK is an ally, whereas Iran and the US have a pretty fraught relationship. And foreign students own stocks, retirement funds inside and outside the US. They can. You don't need to be a US resident or permanent resident to own stocks or retirement funds. However, some stocks cannot be sold to non-US permanent residents or citizens. So you have to check with your broker or the stock seller to see if you qualify to own the stock. The same with retirement funds, but there is no requirement that if you are able to own it, there's no requirement that you stay here in order to. You can manage your accounts online from wherever you are. I'll take questions now.
Okay, so let's start with the questions that came in during the presentation after the couple that I already put out there.
Okay.
There was one that said, when can I apply for a green card after getting an H-1B visa?
You can apply for a green card immediately, because the H-1B visa is the only non-immigrant employment-based visa that allows a person to have non-immigrant and immigrant intent. It's called dual intention. So even though you're in non-immigrant status, you're able to apply without consequence for an immigrant visa.
Okay, perfect. Someone else asked, what about PhDs in the humanities and arts? Whoever asked this, you might want to clarify what this is in reference to.
Yeah. It might be in reference to the national interest waiver, where STEM PhDs are presumed to have met the substantial merit and national importance If you're not a STEM major, you don't get the benefit of that presumption.
Okay. Another question, can we apply for EB2 directly from OPT without getting an H-1B?
You could, but I would do it if you're a STEM major. I would do it after you renew for the 24 months, just so you don't have to put another application, and your application for the national interest waiver, which gives you a green card, is then processed second in time. But that would be my recommendation, because sometimes the processing time may exceed the time you have for your OPT, and you don't want to fall out of status. That's really the main concern, is that as you're pursuing permanent status, you want to ensure that you don't fall out of status. So that's.
Okay. Next question was, can we apply for NIW with a master's degree doing a research on climate change?
Yes, you can, because the EB2 category is for persons with advanced degrees. So a master's is an advanced degree, so you can, and climate change is of national importance. I don't know enough about your exact project to say whether it has substantial merit, but climate change is important. So you're halfway there, let's put it that way.
Okay. Next question was, what are the effects on F1 status of starting the NIW process while still a student?
Well, as we discussed, filing when you're a student, you're expected to return to your home country. So when you file for a national interest waiver, you're essentially saying that you now want to stay. You may have to time it so that you're not traveling, because if you say file the immigrant petition and then travel and try to re-enter on a non-immigrant visa, you might be questioned if they can see you have a pending immigrant visa. You might be questioned regarding whether you are maintaining student status. If you do apply, you want to continue to adhere to all the rules and regulation of your student status, which include taking a full course load, not working off campus during the school year, etc.
Okay. Next question goes back to the processing times. Is the processing time for green cards based on your permanent country of residence?
It is. It's called country of chargeability. So it could be based on where you were born, which passport you have, or if because different people have different situations. If they are permanently residing in a particular country and could be or would be considered citizens of that country. But usually it's birth and passport. And if you have a choice, you can choose. So that if, say, you have UK and Indian citizenships, you can apply based on your UK citizenship, so you don't have to wait so long to get a visa that's charged to India.
Okay. Next question, can I still apply for the green card after I fall out of status?
Well, you can apply, but it depends on the pathway. So if you're an immediate relative, meaning you're applying for the green card based on marriage to a U.S. citizen, then yes, it doesn't matter. You're not penalized. You can still apply while out of status. If you're applying based on an employer petition, you're allowed to be out of status for up to 6 months. And you will need to prove you have status anytime, you'll need to prove you were not out of status for more than 6 months.
Okay. Following up on the question about humanities and arts majors, we were correct about what that was referring to in terms of the waiver. So the follow-up question is, if I am not a STEM major, what choices do I have? Does that mean that EB1 chances are very low?
Well, you're talking two things. The national interest waiver is under the EB2 category. EB1 is something different. No and no, in answer to the question, being a humanities major does not mean you cannot get an approved national interest waiver. National interest waivers are granted based on the proposed endeavor, research project, etc., and whether it has substantial merit and it's of national importance and would be of benefit to the U.S. such that it should waive the job offer and labor certification requirements, which protects U.S. workers because it requires the employer to advertise the job. So that's the benefit to the U.S. workforce of labor certification and PERM. So if you want to apply for national interest waiver as a humanities major, you'll just need to make your case. It just depends on what your proposed research area is about.
Okay. Next question is, what are the costs involved with getting the EB2?
That question, if you're talking about application fees, legal fees, every application has an application fee, and if you use an attorney, it would have the attorney would charge you. So an attorney's charge a variety of prices based on their status as experts and how long they've been practicing, whether they teach other lawyers, etc. All that goes into pricing. So it's difficult to answer that. And then the complexity of your case. So someone who says a PhD STEM major, because they already have the assumption for 2 out of the 3 prongs, their case is a little less intense, time intense. And so it might cost less than someone who's a humanities major, and you have to, work to meet all 3 requirements as opposed to only 1. The application fee, just give me a second, I'm looking it up. The application fee is $700 for the petition that you file with the national interest waiver.
Someone asked about the 3 requirements for the national interest waiver. We will be sending out a copy of the slides, so you can find that information in the follow-up email. Someone else asked, can we still travel to our home country while waiting for EB2 and green cards if they are on a J1 visa as a research scholar?
Okay. The J1 as a research scholar, you may need to find out whether you're subject to the 2-year home stay 212E requirement. and whether you're on the skills list, which requires you to stay for 2 years in your home country. If you file for adjustment of status, you must obtain advance parole, which is travel permission, in order to leave the United States, because if you don't, the application you have pending will be considered abandoned and you'll lose the application fee. You'll have to start over again. Okay. We have 3 minutes left.
Yes, we do. I was just about to say we are coming up on time. There are quite a few remaining questions, but we will be sending a follow-up email to all of you guys who registered that will have the slides, which hopefully will answer quite a few of the clarifying questions so that you can see that information. And then, as always, we do have our appointments available with Patricia through legal aid that you can pursue if you do have more questions. Patricia, we just want to thank you for being here today and for helping our students. As always, we really enjoy working with you guys, or with you. For the rest of you guys, we did put a link in the chat in terms of we ask you to please evaluate our workshop through the survey link. And we have also placed a link to register for our weekly e-newsletter if you are interested in that. I'm glad it was helpful. I do see that comment in the chat, and hopefully the resources will be helpful as well in this email. And we hope you guys have a great rest of your week. And again, Patricia, thank you for joining us with all of this helpful and important information.
Oh, it's always a pleasure to share information with the students. All right, then.
All right.
Bye.
Everybody have a great
Okay.